Good morning. Good morning. Good morning, Facebook. Let me try and get on Instagram. Give me a minute. I think my Wi-Fi's down. Good morning, Instagram. If you can hear me, let me know. Comment and let me know that you can hear me on Instagram. YouTube, good morning. Facebook, good morning as well. If this is your first time, definitely let me know in the comments your first time. Let me know where you're tuning in from. Even if it's not your first time, let me know where you're tuning in from. Um, I have a good topic that I want to talk about today because oftentimes people confuse the topic that I'm about to talk about. So I figured I'm just gonna, talk about it and explain it to you guys. So my name is Aisha Chidole. If this is your first time or you've never tuned into one of my lives before, so I'm an immigration lawyer and I represent clients all over the U.S. with their immigration matters, both humanitarian and family-based immigration, consular processing, Vawa cases, T visas, U visas, naturalization, waivers, misrepresentation waivers, fraud waivers, fiance visa, the gamut, basically. Um, so we assist with those. So today, I want to talk about the key differences and understanding what an I-360 Vawa petition is in comparison to an I-751 petition based on a waiver for extreme cruelty and abuse. Oftentimes, people think the two are kind of the same, and sometimes even USCIS officers make the mistake where we as attorneys have to point them to the rules and correct them. So I'm just going to do a quick explanation of what each of them is, and then sort of talk about what one can do versus what one cannot do. Okay. So, typically with an I-360 VAWA petition, basically, that is a petition when you don't have a green card. So let's start with that. In order for you to submit an I-360, you don't have a green card or your green card has been terminated and you're back at square one, let's just say you're starting from ground zero. If you are a spouse, and I'm going to be talking about this in the context of marital couples, okay? If you are a spouse of a US citizen or a green card holder who's experiencing extreme cruelty, you can be eligible to submit this application, which is an I-360 VAW application. And you can get your 10-year green card as a result of that. The other option is an I-751, which is basically an application that is submitted after you have already received a 2-year green card. So already the first difference is an I-751 application based on extreme cruelty and abuse is done after you have received a 2-year green card versus the I-360 based on abuse is you've never received it. You don't have a green card, basically. Now, the I-751, once you experience abuse after you have received your 2-year green card, you don't have to wait till the 2-year deadline to submit for removal of conditions based on extreme cruelty. If extreme cruelty is already happening to you, you can submit your application. Also, you're not penalized for submitting it late. Again, with the I-751, you already have to have a green card to submit it. With the I-360, you currently don't have a green card and you're requesting a 10-year green card. The I-751, if approved, will also give you a 10-year green card, but remember, you're starting with a 2-year green card. So that's the first and foremost one. One critical difference, this is a key critical difference between the two of them, is that when you submit an I-360 petition based on extreme cruelty, hi, Princess Shamu. I haven't seen you in a long time. I'm glad to see you on here. Hope all is well with you. Okay. As I was saying, when you submit an I-360, should you choose to divorce your spouse while your petition is pending, or you divorce your spouse and then filed your petition, that is fine. However, you cannot remarry somebody else while your petition is pending. This is a key difference. With an I-751, it does not matter whether you remarry somebody or not. So hopefully you guys got that, because that is a very confusing one for most people. With a 360, you cannot remarry somebody else while your case is pending. With an I-751, it is fine. With an I-751, if your green card, even though they haven't made a decision on your green card, and you have had your green card for 3 years at that point, counting your 2-year green card up until date, you can file for naturalization if eligible, based on you being married to a U.S. citizen. Okay. On the other hand, with a 360, you have to have your green card when you get approved for 3 years before you can submit. And you have to have been married to a U.S. citizen to do the 3-year filing, where you can then file for naturalization. Okay, so that is one critical difference. The second critical difference is this: when you submit a VAWA application based on the 360, the actual VAWA decision is made without an interview. When you submit an I-751 based on extreme cruelty, you can either have an interview or you might not have an interview. So we're in a VAWA case where they make a decision without an interview, and then once they schedule you for your green card interview, by law, they're not supposed to talk about the abuse anymore, because they have already approved you for that. And really, this interview is to look at what makes you inadmissible or admissible to the United States. However, with an I-751, there may or may not be an interview. It's truly 50-50. And in the interview, you're expected to talk about what happened and the abuse, or reliving that trauma. And sometimes it can be intense, depending on how traumatic, whatever has happened for, the client. A question that I get asked all the time is, if let's say I filed a VAWA petition and I don't remarry, but I had a baby with my boyfriend, or I had a baby with my girlfriend, is that going to affect my case? No, it's not going to affect your case, as long as this is disclosed. We don't believe in lying to immigration, especially when it's something that's not going to affect you. So it's better to always be upfront and ask for forgiveness for things than not. Because remember, it is unreasonable to expect somebody who has broken up with someone else, or who is divorced from someone else, basically not to be in any other kind of relationship. So if you have a child, you have a child. It's what it is. So the only key thing is you cannot remarry, but it doesn't stop you from being in a relationship with somebody else, or like after you've cleared that other relationship. Before someone says I'm saying go cheat on your husband or wife or whatever, that's not what I'm saying. I'm saying if you've moved on from that relationship, you're not going to be penalized if you are in another relationship with another child. However, you cannot remarry, but with I-751, that's fine. So those are the key differences. Some similarities are that for both of them, if you do get approved, you basically are counting as a green card holder from 3 years. If you've had your green card for 3 years, then you'll be eligible to file for citizenship for both of them. Let's see, what other similarities can I think about with both of them? So with both of them, eligibility of your children, I guess this is kind of like a nuance. It just depends. So if you submit an I-751 and maybe you had a child that got a green card through your spouse, and that child got the green card as well around the same time as you did, or within 90 days of when you got yours, you can submit the one application and just pay the biometrics for the child. With a VAWA case, all children whether or not they lived in that household with you and your abuser, as long as the children are under 21, regardless of where or what part of the world they are in, they are automatically included as long as you've disclosed your children that these are my children. They're automatically included in the VAWA portion of the application. Now, after your VAWA is approved, you can then choose to either consular process, or if the child is already here in the United States, adjust the status. All this will depend on age, but basically, again, it's all children under 21. So hopefully this helps you guys a little bit to kind of understand like the differences between the two of them. With both of them, they're still going to be looking at what do you guys have together to show good faith marriage. They're still going to be looking as your good moral character, are you a good person? And they're also going to be looking for proof of abuse or extreme cruelty. I feel like with conditional green card holders, while it's not necessarily fair, I think that they're a little harder on them for proof of extreme cruelty, because a lot of things that you as a non-green card holder can use to support your case, they find it harder to believe, and we have to do a lot of work to explain to them the psychology of power and control when it comes to being a victim of abuse. What I mean by that is sometimes you might have an officer saying, well, you have a green card, like, so why do you care that they were threatening you, that they're going to deport you? Or why didn't you go report to the cops? Like, they couldn't have deported you, you had a green card. Or why couldn't you just leave? Because you could work. But the thing is, it's the same reason why a U.S. citizen married to another U.S. citizen can be in an abusive marriage, and they know they can leave because there's no issue of immigration, but they stay in that marriage because part of the psychology of dominion and control is that you believe you have nowhere else to go, and people basically try to either financially hemorrhage you or financially control you, or threaten you in a way that you feel like your life is at stake, or even psychologically tell you basically, if you leave, I'm going to kill myself, I'm going to kill you, I'm going to do all that stuff. So those are some of the things, arguments that we have to make. So it's a little bit more challenging, I would say, when you're confronted, by an officer that just doesn't really understand. But that's our job as lawyers, to present the legal arguments and statistics of victims and stuff like that. But basically, the common denominator is, if you are a victim, really at this point a survivor of either of these, being a green card holder but still experiencing abuse, or you're not a green card holder, married to a U.S. citizen or a green card, I will definitely love to help you. This is something that I feel very passionately about. I feel very passionate, and again, this affects both men and women and people in same-sex marriages or heterosexual marriages. So you don't have to be a woman, to be believed. You can be a man, you can be, in a same-sex marriage, you can be, in any of those things. And sometimes, the types of abuse that men experience are very horrific. And for a lot of them, because of the shame associated with it, or saying, how do you tell somebody that you were depressed or abused? A lot of times they won't say anything about it. Okay, so that's that. Let me see if I have any good questions. Stacey Styles, good morning to one of the best immigration lawyers. Thank you so much. Hossein from New Orleans, thank you. Good morning. All right. If someone's I-130 petition is approved for travel documents parole, what next I don't understand your question at all. An I-130 does not give you travel documents. That's a petition for alien relatives. So maybe ask it again. Hi, Barrington from Kansas City. Quick, if you have a pending case, how long will it take to get a green card? That's actually not a quick question, because there are just so many variables. What are you filing for? There's so many ways to get a green card. So depending on what you're filing, all those will depend, When your VAWA is pending, can you get deported? It all depends on strategy and stuff like that. So it's not like they're gonna pick you up. Like if you're already in the United States and you already have that pending file, usually you'll have an opportunity, we have an opportunity to either, let's say they send you a notice to appear in front of an immigration judge, which has sometimes happened either simultaneously as we're filing a VAWA application and they're doing that. We have the opportunity to say to a judge, we have a VAWA petition that was filed. Here's a filing receipt, or here's a prima facie. Can you administratively close this case and allow them to make a decision on this case? And if they approve them for the VAWA, then we can go back, to the government and say, join us in this motion. Let's, tell the judge this person has been approved. Just go ahead and terminate this case. Because, guys, I promise you that immigration judges are not like sitting there thinking about who am I going to deport? How many more people can we deport? For most of them, they want to get cases off their dockets. They want to get cases off their files. That's what I mean when I say dockets. So if there is another avenue where that person is eligible for something, they're certainly willing to consider that. And especially in this administration where prosecutorial discretion is something that is encouraged. And speaking of prosecutorial discretion and removal cases, I just want to point out to you guys, and I've said this before. I remember I said in the last administration as well, when you qualify for something, it is important that you don't sit down and dilly-dally. Do not sit down and dilly-dally, because immigration rules change by the hour on the hour. You might be eligible for something today, and then next week you're not. I cannot tell you since the month of September how many people who are married to green card holders that have come to us that were kind of like sitting down and just didn't do anything, that are no longer eligible to file, because that just changed like that. So you should not be sitting down or just, they say some people, they just consume information, but they don't really do anything with it. So don't just sit down and jump from one lawyer to one lawyer's live or the other lawyer's lives. If you're eligible for something, or you want to determine if you're eligible for something, schedule a consultation. If you're eligible, file for it, because you don't want a situation where when you're ready, you no longer are eligible. And speaking of that, for the whole month of November, our consultations are $99. That's our Thanksgiving sale. So definitely get in. Our consultations are normally $150, but we're offering them for $99. So lock that in and schedule your consult. And for those of you who need my number, it's 407-995-6567. You can also send a message on WhatsApp, 404-333-8751, and let them know you want to schedule a consultation. Okay. Christina says, good morning from Maryland. I want to file for a fee waiver after my VAWA has been approved. I'm going to file the fee waiver with the green card application. I have 4 kids. I would like to expand on that. If you are eligible to submit a green card application at this time, I would not necessarily wait till your VAWA is approved. Most VAWA cases take 2 years to 2.5 years. So you now enter another timeline from an adjustment of status. So what I do recommend, without knowing your case, but if you are eligible, which would require screening, if you are eligible to do your adjustment of status, you want to file your adjustment of status at the same time as when you submit your VAWA case. But, happy to chat with you to see, if you are eligible. Okay. Okay. So Shamu says, you sent my prima facie in December of 2022. It'll be expired December 2023. What next? I filed my immigration paperwork since November 2020. Okay. So definitely you filed your other immigration paperwork, not your VAWA immigration paperwork. Because if not, you wouldn't have the 1 year prima facie. So that would have been submitted in 2022. Not 2020. If you filed in 2022, you're still looking at, from most VAWA cases, take about 2 years to 2.5 years. But that being besides the point, when your prima facie expires, USCIS is going to automatically renew it. So don't worry. Whether it comes 1 minute, 2 minute, 3 minute late, your prima facie is still on file, meaning they've already checked that box. It's just that sometimes, it comes late. Once they issue it, it'll be sent to you, but it's usually issued after the expiration date. Okay. Okay. 2 weeks of filing Vawa, I got a receipt notice from Nebraska. Then 3 days later, they updated that fingerprints were taken. I'm guessing they took that from my prior case from my husband. Possibly, yes. Ole says, how do you start with a 2-year green card? When you're newly married, can you submit an I-751? This is a very, very good question. So basically, the way you get a 2-year green card, or the way USCIS decides who to give a 2-year green card versus a 10-year green card, is when you marry and you file for immigration for a green card. At the time of approval, if you've been married for under 2 years, automatically you're going to get a 2-year green card. If you've been married for more than 2 years, automatically you're going to get a 10-year green card, and then you don't have to deal with that. So that's how you get a 2-year green card. Any marriage that at the time of approval has been under 2 years, you will automatically get a 2-year. Basically, it's like a trial period to see, okay, in those 2 years, are you guys still, legit? Is your marriage legit? And, stuff like that. Okay. Princess, yes, call us 407-995-6567 to schedule a consultation, okay? Can you divorce while an I-360 is pending? Yes, a divorce can happen while an I-360 is pending. If you have not submitted your VAWA application and you do get divorced, remember that you have a 2-year clock. You have to file VAWA within 2 years before the anniversary of the second year of the divorce, okay? Grateful says, how can I adjust my status here in the U.S. for an approved I-130 for a married child over 21 years with overstayed? So are you a married child over 21? If you are, more than likely you cannot adjust your status here. You're going to have to do I just lost my train of thought. You have to get a waiver. You have to do a 601 waiver. Okay? Yeah. All right. Okay. All right. One more question and then I will jump off. Mom says, I filed a VAWA petition over a year and my case is still showing the same thing. There's no update as of yet. Do you know how long it takes to update? So sometimes USCIS just doesn't update things online. And usually for VAWA cases, you're not going to see any updates online unless there's something wrong with your case, because it takes them 2 years, 2.5 years to make decisions on the case once they, have your case. So they're not going to have any kind of update on there unless they request additional evidence. If they request additional evidence, then they will write it on there. And they will send you that request, or if they approve your case. All right, guys, I'm way out of time. I have a meeting. I will talk to you guys later. Have a good day. Bye.